And welcome to this episode of the Good Citizen Podcast. Today, I want to dive into some recent legal developments around faith at work, and specifically the ability of a Christian to go to an employer and say, look, I believe I need to be at church on Sunday, and to be able to get an accommodation for that belief. Also, another case that's come up recently is whether or not a teacher at a public school can go to the superintendent, school board, and say, I have a deeply held belief against using transgender preferred names and pronouns. It's against my conscience. I don't believe that to be true. I cannot in good conscience say what I believe to be false, and whether or not that particular employee could receive an accommodation for that, or if the school could actually force that individual out of employment. So these are not hypotheticals. These are cases in front of federal courts. First of all, Groff is going to be heard actually today, Tuesday, April 18th, for oral arguments in front of the U.S. Supreme Court. And then the Kluge case was recently decided by the Seventh Circuit. The Groff case is directly relevant to that and perhaps could change a few things there. So this is really critical. I mean, you think about church leaders, fellow committed Christians that are out, wanting to practice their own faith of saying, look, church attendance is important. Hebrews 10:25, you need to be there, you need to fellowship. But also saying, look, you need to live out your faith at work. This is part of following Jesus. So these, again, not hypothetical. These are legal principles, legal standards that are directly affecting, and these are legal standards that will affect Christians as they attempt to do this moving forward. So I thought it was important to take a little bit of time to walk through some of the facts of these cases so that you're updated, you know what's going on. The first case, as I mentioned, is called the Groff case. This had to do with a mail carrier in rural Pennsylvania. He grew up in the town, believed that, hey, working for the Postal Service, that's going to be a steady job. It's a respectable position. And when he signed up, the mail service did not run on Sunday. So it did not conflict in any way with his Christian belief of attending services on Sunday. Then the Postal Service began delivering packages on Sunday for, you probably guessed it, Amazon. And there were only 4 workers. At first, one of them would cover for him. I believe that worker became ill and was no longer positioned to do so. And so eventually that local post office told him, look, you have to work on Sundays because there are not enough Postal Service workers, and we're not going to provide an accommodation for you. So it's either decide, go against your beliefs of attending church on Sunday, or you can't work here. And he appealed that to now the U.S. Supreme Court. So what's kind of the legal side of this? Now, if you just look at the First Amendment to the U.S. Constitution about Congress not making a law respecting an establishment of religion or prohibiting its free exercise, you would think, well, this seems like a no-brainer that certainly the Postal Service, a government organization, should have honored this accommodation request. But essentially what's going on here is a case of some precedent that has been in U.S. law for some time, criticized for a long time as well. It's called Trans World Airlines versus Hardison. It involved a Saturday Sabbatarian that wanted to be able to worship on Saturday. And what the court decided in that case is that in the Title VII context, and Title VII is the part of the Civil Rights Act that deals with religious beliefs, essentially says that religious workers should be accommodated. They should be free from discrimination. They should be free to be able to work and live out their faith. And essentially this law says that those employees must be accommodated by an employer unless it would become an undue hardship for that employer, which sounds like a fairly high bar. I mean, it has to be an undue hardship. It's got to be something substantive, right? But in Trans World Airlines, the way that the court interpreted undue hardship is to mean that the employer must bear more than a de minimis cost. So de minimis, it is defined exactly as it sounds, that, as long as it's more than just something really slight, then employer, you can't be forced to accommodate the religious beliefs of an employee. And so that the protection in Title VII was essentially gutted, because as long as a government agency or a business says, your religious beliefs, if maybe you want to go to church on Sunday, or you have a particular belief, and you have an objection to saying something in the workplace, participating in a particular activity, as long as that's going to cost us more than just something really small, then we don't have to accommodate you, and either get on board or you're out of here. And so this has been a troubling opinion for a long time. It's interesting, even Americans United for separation of church and state says that this is wrong in too many ways to stand. And Americans United for separation of church and state would often stand against some of these kind of religious liberty cases, advocating for greater accommodations for religious employees, that sort of thing. And so it's interesting that they would say it is wrong in too many ways to stand. Now, essentially what Groff is arguing is that there is a comparable standard in the Americans with Disabilities Act. And I'll pull all the pieces back here together, so stay with me for just a second. It's legal language, but it's really important for us. The Americans with Disabilities Act would say that an employer must provide accommodations to an employee unless that accommodation would impose an undue hardship on the operation of the business. So the same kind of undue hardship language, except that it's largely in the ADA defined as something much more substantive, much more along the lines of what you'd actually think undue hardship would be. For example, a 2015 Federal Court of Appeals decided that a call center that relied on a software that was inaccessible to blind employees may need to pay at least $129,000 to accommodate those employees. So paying, almost $130,000 would not impose an undue hardship on the operation of the business, but simply asking the Postal Service to make room for an employee that wants to go to church, that doesn't fit the bill. So essentially, Groff is arguing, look, the standard in Title VII, which again deals with discrimination against employees of faith, people that practice their faith, religious employees, that the undue hardship standard in Title VII should look a lot more like the undue hardship standard over in the Americans with Disabilities Act. And so that's basically the argument in front of the court. So it's interesting the court accepted this case right now, because back in 2020, there was a Seventh-day Adventist that made a similar claim about being able to worship on Saturdays, and even some of the conservative justices did not agree to take the case. And so for whatever reason, the time has come where this high court is willing to take this up. How are we going to treat people of faith here in the United States? Are we going to treat that as just something light that can be just dispensed with? Hey, just get over that. You need to get here and deliver the Amazon packages because everybody needs their stuff. There's maybe an entire episode just on that. But the Supreme Court, I hope, will actually change this so that it is more like the ADA standard. Maybe they'll land somewhere in between the current Title VII and ADA standards, but it certainly needs to be reviewed. Certainly, the standard cannot be that as long as the business says, well, it's, this is going to cost us more than something really small, therefore we don't have to accommodate you. And that brings me to the next case, which certainly church attendance is important and serious. This next one is kind of just as serious and just as important, having to do with the Kluge case. John Kluge was a music teacher at a school actually here in Indiana, in Brownsburg, Indiana. And he went to the superintendent of the school after there was a policy published that teachers must use the preferred names and pronouns of transgender students. And he said, he told the superintendent, I cannot in good conscience do that because I don't believe this to be true. I cannot in good conscience say what is untrue. And at first, the school was willing to accommodate him through the use of last names. But then the school changed the policy after receiving complaints from faculty and students. And Kluge sent back a request like, all right, you told me I'm okay using last names, then you changed the policy. Does this apply to me? And they basically told him, look, you can abide by the policy, use the preferred names and pronouns, you can resign or be fired. So he resigned. Now, one of the things that is certainly concerning is that this is not a free speech case. Now, you would think this is using pronouns, this is verbally speaking about preferred name or pronoun, but there is a case called Garcetti that involves teachers in kind of the K through 12 setting, and specifically public school teachers. And Garcetti is a very difficult precedent because essentially teachers, when they walk into that space, they are agents of the state, and public schools have a lot of authority and a lot of control over what those teachers can say. So the Public School Corporation can do this. Certainly the state legislature, which has some authority over that, can direct it. You're seeing some of that go on in Florida, and there are big fights and litigation over this. Now, if you're in the university setting, there's a lot more freedom for employees. But in the public school setting, and I think, again, Garcetti is wrongly decided, it almost strips away all First Amendment free speech protections for public school employees. So again, I think that's wrongly decided. So he can't necessarily rely on a free speech argument, which would often be some of the strongest protections in American law right now. And so he couldn't rely on free speech protection. So what claim did he have? Well, he had a Title VII claim, saying you can't discriminate against me because of my religious beliefs. I should be free to live out my faith here in the classroom. I'm trying to work with the school. I'll even use last names. And essentially what happened there is that the faculty protested, students protested, and complained, saying that the use of last names stigmatized them, the transgender students. And so there was pushback from some of the students. There was evidence in the record that there are a lot of students that said, this isn't disrupting anything. This isn't causing a problem. He's just using last names. And what's one troubling aspect of this case is that it was decided on summary judgment. It wasn't even allowed to go to a jury to determine this matter. And essentially, back to what's going on in the Groff case, the Seventh Circuit held, look, it would have caused an undue hardship to the school. And what's the standard? Well, back to, it would have been more than a de minimis cost. Now, this is extremely troubling. Why? Because as long as you have students or faculty that end up disrupting things, it's not Mr. Kluge that it was disrupting the classroom or causing issues or raising complaints. It was faculty, it was students. So, as long as the faculty and the students scream and yell and get angry, and we've seen this, if you think back to what happened at Stanford Law School here recently, as long as they cause the disruption, then the teacher can't be accommodated. And so it takes the ability of a teacher or a religious employee to say, look, here's my belief. I want to work in good faith with other people, but here's my beliefs, and I need to be accommodated here, and I'm going to respect others. I'm not going to call them by a preferred name or pronoun because I don't believe that to be actual or true. And apparently, American society isn't big enough. We aren't in a place where we can actually have those kinds of conversations. No, what has to happen in that case, just because you're going to have faculty and students that are upset because this teacher won't get with the program, is, well, that teacher has to be fired. Again, surely this is not the result. This is certainly not what the First Amendment anticipates in the United States, that a religious believer coming into school saying, look, I'm going to do my best not to have difficult conversations or call someone a name. I simply cannot say what I believe to be false. And just because the school says, well, that's going to cause more than a de minimis problem here, we've got faculty and students upset, therefore you're out. And here's what the circuit judge in this case held. Kluge's last name only practice stigmatized the transgender students and caused them demonstrable emotional harm. This is what a circuit judge said. In a dissenting opinion, another circuit judge, Judge Brennan, said it was unclear whether the school could have mitigated any disruptions resulting from Kluge's conduct, and that a jury should decide whether his rights were violated. Again, this was decided on summary judgment. It wasn't actually allowed to go to a jury. There's a principle in First Amendment law called heckler's veto, where if someone is speaking, you can't come in and just kind of shout them down and kind of cause the disruption and then say, well, there's a problem here. This is getting out of hand. Therefore, speaker, you're coming in. These people came in. They're screaming at you. They're causing a problem. Therefore, you can't speak. It's called the heckler's veto. And what's essentially happening here is, the heckler's veto is not in the Title VII context, but essentially that's what's going on. As long as the students would cause a disruption over a Christian teacher saying, look, I can't in good conscience support the transgender movement, transgender ideology, as long as a disruption is caused by students, they can be forced to leave because it creates, under this precedent, a more than a minimis cost to the school. Again, I wanted to bring this up today because this is concerning. This is alarming. If that is the standard, Congress passed Title VII to prevent employers from forcing workers to abandon their beliefs to keep their jobs. That's the purpose of Title VII. Well, how is it working? And again, this isn't just for the Christian. There are many other, even non-secular teachers that don't go along with the transgender movement. What about Muslims, Sikhs, Buddhists, etc., that would say, I can't in good conscience do this? They're basically being told, you have to abandon your beliefs or you can abandon or lose your job. So the Groff case is certainly concerning because it deals with church attendance. The Kluge case, because it deals with this very recent development of employees being told you must affirm. It's not that you can just tolerate it. No, you have to verbally affirm this belief. And so it's not just, hey, be okay with it. No, you must participate in it. I've often said over the last year or so that we've got to move from an acceptance phase in the sexual revolution to an enforcement phase. And to have a federal circuit court to go along with this is gravely concerning. And so I wanted you to be aware of what's going on so you can be praying. I did want to close out with a couple of reflections from these developments. And the first one is what it says about our values. And of course, a circuit court or federal court's not really in a position to comment on some of this. But these cases really signal what we believe to be important, don't they? This says that our around-the-clock, never off-work schedule and our need for stuff, which has to be there. No, the Postal Service didn't cause that. Amazon didn't necessarily cause that. It's more just our need for stuff as people. And again, if we're just being honest, just thinking about some of the cultural issues here, that we're saying, look, that's more important. Getting my stuff within 2 days via Prime, that is more important than this individual, Groff, being accommodated so he can go to church. Like, what does that say about our society? And look, I'm grateful for the hard work ethic of the American people, and it has brought us great prosperity. We shouldn't be lazy. But as Scripture speaks about the Sabbath, and I preached about this holy habit of Sabbath, that what Scripture says about that's good for us, but it's really good for all people as well, that we're not made to always be on. But essentially what we're saying as a society is, no, we value this always on, around the clock, never off type of schedule, and you've got to have our Amazon packages within 2 days or else, all right? And essentially the kickback here from a policy or value perspective is that, look, government already has rules that says that in the case of a disability or something like pregnancy or health issues with the FMLA, that we're going to make room for people that have these things. So this case, the Groff case, is really a question. Do we actually value religious practice? Do we actually value people saying, look, I need to go to church? We have a mental health meltdown in this country. And why is that? Well, maybe because we're around the clock and we're always on. We always have social media. This individual raised their hand and says, look, I believe that I need to go to church. I need to worship with my family. I need to spend time with God. And so this case is really about, do we value religious practice, or is it something so trivial? It's something we don't believe in enough anymore. It's just not important, something that a few people do, and maybe that's respectable, but it's just not really that important. And to kind of emphasize this point, there's an interesting Vox article on this, and they go into this they call it a practical reason why the Groff case is concerning. And I'll read a little bit of this. So the practical reason, meanwhile, is that requests to accommodate a disability are fundamentally different from requests for religious accommodation. I'll read that again. The practical reason, meanwhile, is the requests to accommodate a disability are fundamentally different from requests for religious accommodation. The purpose of a disability-based accommodation is to ensure that a worker can do their job, even if their disability might sometimes prevent them from doing so. A worker with carpal tunnel syndrome, for example, might request a keyboard, or a worker who uses a wheelchair might request ramps that will allow them to easily traverse the office. The scope of a disability-based accommodation, however, is bounded by the nature of a worker's disability. Once the worker with the disability is able to successfully perform their job, they have been accommodated. Requests for a religious accommodation by contrast, are bounded only by an individual worker's religious belief, and goes on to voice concerns that this might involve a religious worker trying to proselytize fellow employees, or refusing to work with a gay or transgender employee, and kind of goes into all of these requests. Now, I certainly am grateful for the ADA and the fact that we do accommodate those with disabilities. But to say, look, granting an accommodation for an individual with a disability, it's important, and that's sound policy. But do you hear them basically saying, but the request for religious accommodation, it's subjective, and it could be anything over the board. It could even be used against the gay and transgender community. And so it's just not the same. It's just really not as important as an accommodation for an individual with a disability. But the law basically says, through Title VII, no, we see all of those the same. We should see all of them as the same. That's essentially what I would argue, and what I think the law actually states. But just from a cultural perspective, understand where this is coming from. We're essentially saying, look, we value our around the clock. I can get my Amazon Prime in 2 days, but this guy that just wants to go and worship with his family, we just can't abide it. We just can't grant that. It's just not important enough. At the end of the day, I believe that is what we're saying as a society. It is a grave concern. And, how do we push back on that? Well, some of it is, let's prioritize church attendance. Maybe part of the reason why our culture doesn't value it as much is they don't see us practice it. And maybe if more Christians would stand up and say, look, this means something to me. This is something I'm commanded to do. And I can't just, because you tell me I have to come in or lose my job, I'm going to have to make a hard choice here. But I shouldn't have to. And if more Christians would actually say, this is something I'm going to value, maybe our culture would get the cue as well. And so I didn't want to leave off today without emphasizing that a bit of what this says about our culture, and what we are saying is important as well as believers. And the second aspect of this is, if you had told me a few years ago, in this case, kind of the fact pattern began in 2017, even if you've told me in 2017 that the legal standard is that a public school employee can be forced to resign if they will not use the preferred names and pronouns of a student, I would have told you, no way. That is not the First Amendment. I don't think that is where jurisprudence is going to go. That seems a bit alarmist. Well, now you have a published opinion from the Seventh Circuit Court of Appeals that says exactly that. So let that sink in for just a minute. It is odd to me that you would be forced to pick between your job and your beliefs. And sometimes, as you look back through Scripture, the decisions that we studied Daniel extensively last year of, where they would end up having to make a choice and to make a stand. Sometimes you would have never anticipated that this was the place where you'd have to draw the line and say, I can't in good conscience do this. But it's here. And again, if you told me a few years ago, that's the standard, that's the issue we're going to be dealing with in our culture, I said, no way. But here we are. There's a Seventh Circuit Court of Appeals opinion that says, really, as long as there's a disruption, and certainly students could cause that, faculty could cause that, if in our society now, every reason to believe that could occur, as long as that is treated as more than a minimis cost by the school corporation under the standard we talked about today, that Christian employee is in a hazardous spot. And so I wanted to bring this up to you. The Groff case, again, hasn't received a lot of attention, but for the reasons I've stated today, first for Groff, for being able to attend church, but then for Kluge and what's happened here in the Seventh Circuit. Again, applying just to the Seventh Circuit here in the Midwest, there would be other circuits that are dealing with this around the country. It might land in a different spot, ending up probably at the Supreme Court. But this is something we should be aware of, and something we should pray about. As we are working to help people follow Jesus, we want to make disciples. The area of how you can live out your faith at work is not inconsequential, because we spend so much time there, and Christians should be free to be able to live out their faith in the workplace. And so I wanted to update you on that. We'll see how the oral arguments go. But a lot of times, Christians will follow some more high profile cases involving life or religious liberty. Well, this is one that I encourage you to follow and be aware of, because it certainly can impact every ministry, every Christian home in the country. And so that's an update there on employment law as Faith at Work makes its way to the Supreme Court. Let's be in prayer. Let's follow these developments. Even reach out when possible. If there's a legislative opportunity, maybe you could reach out to your elected officials about this case as well. But I wanted you to know about both the Groff case and the Kluge case. We'll be tracking those with you, and just continue to pray for Christians around the country that we develop that courage and that the wisdom to know kind of when to stand, but also the courage to speak up and to say, look, we should be free to live out our faith in the marketplace. So that's the update for today. We'll look forward to being back with you next week.